Hello friends, how are you? Today I am going to discuss an important topic of offense of defamation. As we know that the offense of defamation is defined under section 499 of IPC and it is punishable under section 500 of the IPC. And in addition to law of defamation, we are having law of insult, which is also a penal offense as per section 504 of the IPC. And apart from that, we are having the offense of criminal intimidations. So we could say that defamation, insult and criminal intimidations are sister concerns. But today we will emphasize only on offense of defamation. As we know that defamation is also a civil wrong and specific provisions regarding the same has been incorporated in the law of torts also. But law of tort is not codified, it is usually based on judicial pronouncement. Then what is codified law? The codified law on this subject is section 499 of IPC. IPC means Indian Penal Code. So it specifies certain categories that if you are doing an act with intention to lower down the image or esteem of a person before the public, you would be liable for offense of defamation. So basic criteria is that the image or the esteem should be lowered down before the general public. If it is not, it would not be an offense of defamation. And apart from that, sometime our neighbor is going to affect our rights. He is going to create the nuisance. He is going to do certain things in respect of which we have a right to make a complaint before the police, before the concerned court, before the concerned administrative authority like collector or ADM or SDM. And here we are having the excellent case of Honorable Supreme Court, which is recently pronounced on 2nd of August 2022. The case title is Kishore versus State of Maharashtra. In this case, a very important point is that a complaint has been filed by the concerned accused, who is appellant in this appeal, by mentioning that the concerned complainant inter alia affecting his right in the following 2 ways. Number 2, by encroaching upon his land and by gathering the anti-social elements. So the rights of the concerned accused appellant could be affected. When the notice has been issued, the concerned complainant filed a private complaint under section 499 with section 500 of the IPC. He has testified himself as per the protocol of section 200 of the CRPC. And subsequently, other witnesses has been examined as per the protocol of section 202 of CRPC. And finally, the concerned magistrate issues summons as per section 204 of CRPC with section 190 subclause 1 subclause A of CRPC. Finally, when the accused appellant appeared before the concerned trial court, he has filed the recall petition. It was accepted and proceeding has been quashed. And ultimately, the concerned complainant has moved to the higher court, that is Court of Session, by submitting that the recalling of order is not permissible, and that's why, by getting convinced from the argument of the concerned complainant, the order passed by the concerned judicial magistrate on the recall petition is set aside and the matter is remanded back. And finally, after a delay of 8 years, the concerned accused had went before the Honorable High Court by the virtue of writ petition, by praying that the proceeding conducted by the concerned trial court is abuse of process of law, and that's why it is liable to be rejected. But unfortunately, the concerned High Court has rejected the petition merely on the ground that no ground to interfere made out, because the petition is filed with a huge delay and the reason for delay is not explained, and that's why we could conclude that the only reason that has been assigned by the concerned High Court is that the writ petition is filed with a delay, and that's why there is no ground for any interference. You got the point now? Very easy here. And ultimately, he went to the Honorable Supreme Court by mentioning certain fact. The prime fact is that the case is not made out, entire proceeding are abuse of process of law, and the concerned High Court had ample power to exercise jurisdiction as per Article 227 of Constitution of India or Section 482 of CRPC. Because the ultimate aim of this power is to prevent the abuse of process. So the entire study is confined on abuse of process, and in that scenario, the scope of study is quite limited. He has to emphasize those facts which are uncontroverted, and even though the fact assigned in the complaint and other proceeding are accepted as gospel truth, no offense under section 499 of IPC is made out. In the last, he submitted the 4 important points. Number 1, if the accusation is made in the complaint in writing to the concerned person having the lawful authority over such subject matter of accusation, in that scenario, no offense of defamation would be made out because it is specifically spelled in section 499 exception number 8 of the IPC. That is very important argument. Number 2, Apart from that, he emphasized that he always acted in good faith because all the allegation is supported by some evidences. And apart from that, he has duly followed the basic protocol of section 52 of the IPC. Third point is that I have not done any offense. I have made the complaint, which is my right. If I'm exercising my right, I'm not going to cause the defamation. And number 4, the basic criteria, the lower down the image before public. Where is the public? If the basic ingredients are absent in that scenario, I could not be prosecuted. So in that case, the court, while looking to the fact circumstances, had quashed the proceeding by relying on these legal provision and the scenarios. So in last, we could conclude that if you are having the same problem, just scrutinize the entire complaint, do the research work, do the proper brief, move before the Honorable High Court or Honorable Supreme Court for the vindication of your remedy. Because if at the first instance we got succeeded to quash the proceeding, in that scenario there is no requirement to face the huge trial proceeding before the concerned courts. So it is your rights in which manner you are going to enforce. If you are not going to enforce, the opposite party will take the advantage of its own wrong. So be aware about your rights. If the rights are available, no one is here to tell you, but I am going to enlighten you so that you could know about your basic rights. So friends, see you in the next video. Till then, Jai Hind, Jai Bharat.